We begin tonight with the decision from the OECS Court of Appeal on the election petition filed by the United Workers' Party after the 2011 general elections. St. Lucia recorded a historic judgment in election petition matters on Tuesday. The Court of Appeals sat in St. Lucia's High Court to deliver a legal ruling on questions of law as submitted by the claimants and respondents in the 2011 election petition case filed by the United Workers' Party. Outgoing Chief Justice Sir Hugh Rawlins deemed this decision an important one, as it sets the precedent in this jurisdiction for subsequent matters. He reminded the court that law in relation to election petitions is a complex maze, and not many lawyers have practiced in this area. The basis of the UWP's submission to the Court of Appeal is its reliance on the Civil Procedure Rules, the CPR, to justify actions and discrepancies on the claimant's part in the filing and execution of election petition proceedings. The Court of Appeal ruled that the CPR is not generally applicable to election proceedings and that the rules apply only when there is an expressed statutory or constitutional power. Further to that, the CPR can only apply to election petitions in a limited capacity, as the rules laid out by the Election Act is expressly stated and should be strictly adhered to, including the deadline for filing. A petitioner cannot rely on any provisions under the CPR for an extension of time. The opinion added that the Elections Act has to be complied with and cannot be circumvented with the CPR, or else the petition will be considered null and void. The Chief Justice then went on to state that returning officers should be listed as respondents because the main issue is with the ballot count. In essence, the court ruled that the CPR cannot replace or amend any constitutional or statutory provisions for election proceedings. The case was sent back to the High Court for hearing. Amid the opinions given by the Court of Appeal, the UWP is still optimistic about its prospects at trial.
I was not expecting the decision the judgment we were hearing to be so complex and complicated. On the other hand, what we had is a situation where everybody recognized that, for example, the petitioners were not signed by the petitioner as required under the law, under the Petitions Act. I was very happy to hear the Chief Justice saying that it is not a matter of, we were arguing that this is not substance but rather form, and this came out throughout the rendering of his decision, the decision that it was a matter of form, not substance. Form meaning it is an irregularity in somebody not signing, and I think he gave the direct analogy or the actual example. So I think that augurs well for us.
Meanwhile, still in news from the court, a police officer who is the criminal court crier was arrested on Tuesday by the drug squad on the court compound. He was found to have what appears to be marijuana in his possession. Sources say he was seen receiving a package from an individual and hiding the contents on his person. Officers immediately intervened. Police sources close to the investigation revealed that this may be an ongoing investigation, as officials had previously expressed concern about drugs coming into Bordelais through prisoners who had gone to court.